The Honourable Phil Goff.
Mr Speaker, Labor supports the Judicature Modernisation Bill. I've got to say, Mr Speaker, it's a little hard to do justice to this bill here tonight in a 5-minute speech. I've got 50 seconds per 200 pages, so I'll have to rush it a little. My colleague Chris Farfway will move an extension of time, I'm sure, and it'll be endorsed by everybody in the House. Mr Speaker, this is a good piece of legislation. It's very worthy, which is sometimes another word for dull. It's based on the Law Commission report, the review of the Judicature Act 1908 towards a new court system. And I think you'd have to say, Mr Speaker, that after 107 years' time, it is about time that we rewrote it. It's outdated, it's inconsistent, and it's the current act, and it's quite difficult to follow. We've modernised it, but it's fair to say that the terms of reference for the drafters did not include the words concise or succinct. In fact, sir, I think at 1,226 pages long, this is longer than the Concise English Dictionary. And when they call it an omnibus bill, I wasn't sure it was because it covered a whole lot of bills or because it was the size of a bus. I think probably a little bit of both. What it does, however, does make sense. Part 1 brings all of the senior courts together into one bill. Part 2 makes a unitary district court so that the other courts become specialist divisions of that court, the family court, the youth court and the disputes tribunal. Part 3 deals with a quite modern piece of legislation, only 43 years old, the Judicature Amendment Act, and it updates that. Part 4 is the government response to a specific Law Commission report, which is aspects of damages, the awards of interest on money claims. And Part 5 is quite important because it enables the use of electronic technology in court proceedings. But, sir, I want to associate myself with David Parker's comments on this bill. When I read the commentary, it says the bill is intended to make the justice system more people-centred, modern and accessible. Now, by accessible, I guess they meant it's easier to find where the legislation is. Because if they were saying accessible in terms of people's access to justice, sir, that would be quite wrong. And obviously, access to justice is a lot more important. If you really believed that the justice system was equal and we were all equal under the law, you'd have to argue that the person who can afford to employ the QC has the same standing as the person on legal aid, or worse still, the person who is not eligible for legal aid. Because the changes made in this House in the last 5 years on legal aid says if you're on the minimum wage, you're not eligible for legal aid, for God's sake. You have to be on a benefit in order to get legal aid. Who in this House could say that is justice? And I have to say, sir, that last year when we passed the Family Courts Act with our opposition, that made the law less accessible to those who are most vulnerable, particularly our children. So accessibility is not what this bill actually achieves. Sir, I want to, in my last couple of minutes, refer to the minority report of the Labor Party and its particular reference to the Speaker and the Chair. It says that there's a retirement age of 72. Well, that's actually against the Human Rights Act in terms of the Human Rights Act saying that we shouldn't discriminate on the basis of age. I'm sure that there are judges aged 72 who are just as capable of you, Mr Speaker, despite their advanced age. And it shouldn't be based on the nominal age, it should be based on ability to do the job. The second and most important point is that this bill explicitly excludes what is in the Supreme Court Act, which talks about the independence of the judiciary. And the independence of the judiciary in a country that does not have a formal written constitution should be written into the law. Jack Hodder and other people that are eminent in the law have said this is a mistake, and not one national member of Parliament has stood up to justify why we have taken out reference to judicial independence, which is a fundamental foundation stone of the democratic system.